Good afternoon from Hong Kong, and good afternoon to audience from Asia, and then good morning to audience from UK and the Europe. My name is Wei Xia Gu. I'm an associate professor at the University of Hong Kong Faculty of Law. Well, and then today we are very honored and delighted to host the book talk by Professor Mimi Zou, who has a concurrent joint appointment at University of Reading and University of Oxford. Mimi is my old and good friend, so I'm very delighted to organize this book event for her. So in addition to Mimi, we are also very delighted to have Dr. William Wang at Sea, who is a leading suit in town. And then William will join as the discussant for Mimi's talk. Now, before Mimi kick off, let me give you just a summary and then a very brief introduction of the two speakers today. But if I spend the whole time on profile, then I would probably spend about 10 to 15 minutes. But just give you a heads up. Mimi is associate professor at the level of reader at University of Reading in UK, and director of studies law at the Regent's Park College, as well as inaugural Fang Da Career Development Fellow in Chinese Commercial Law at St. Hugh's College, both at University of Oxford. Mimi's main areas of expertise are in Chinese and comparative contract law, employment law, law and technology, and commercial dispute resolution. Her research has won or been shortlisted for prestigious international prizes and featured in global media outlets. Mimi has a very impressive academic background. She obtained her DPhil and BCL degrees from Oxford with high honors. She also graduated with first-class honor degrees in law, economics, and social sciences as a university medal recipient from the University of Sydney. And prior to her current role at Oxford, Mimi held appointments at Columbia Law School, the Chinese University of Hong Kong, and Utrecht University in Netherlands. Now let me turn to Dr. William Wang. William is a senior counsel at Daewoo Chambers, one of the most famous barrister chambers in Hong Kong. William has been in practice in Hong Kong since 1998. In 2013, William was appointed as a senior counsel in Hong Kong. He is also presently a non-executive director of the Securities and Futures Committee and one of the vice chairmen of the Board of Review of the Inland Revenue. William's practice covers a wide spectrum of contentious commercial litigation. He has a special focus and substantial experience in the areas of company, insolvency, and securities law. William also sits as a seasoned arbitrator in a substantial number of international commercial arbitration cases. On the academic background, William is a graduate of the CUHK. In 1994 as the Rhodes Scholar of the Year. In 1996, he obtained his MA in jurisprudence from Oxford, and he further obtained his LM and PhD from the Peking University Law School, with the dissertation written on corporate insolvency laws. William also serves on a number of special subcommittees of the Hong Kong Bar Council, and he is the vice chairman of the Committee on Overseas Lawyers Examination and the Committee of Mainland Affairs. Now, as I said, they have very impressive profile, and I will stop here. I will now turn to Mimi to introduce her wonderful book, very timely book. It's beyond words how important the Chinese civil code is to everyone, whether from academic point of view or practitioner's point of view. So turning to you, Mimi, thank you.
Thank you so much, Professor Gu, Wei Xia. And I just also want to reiterate my thanks to Dr. Wang for being a very dear friend and colleague over the years. And it's great to be speaking to probably a predominantly Hong Kong-based audience. I spent several years in Hong Kong at Chinese University, and perhaps some colleagues also from Chinese who are here. But really just want to say just how delighted I am to be hosted by the Center of Chinese Law at Hong Kong U for this book talk. It's actually my first official book talk, and I sort of chose Hong Kong because I think obviously the significance of the civil code for many practitioners and researchers in the region due to, I guess, the transactions that you're all working on that most likely involve some element of Chinese law. So the Civil Code is really a historical milestone that I'm sure you've all heard about, and maybe some of you have even had the stamina to actually go through the 7 books, several thousands of provisions across different areas of civil or private law in the PRC. So for some, this massive piece of legislation is probably difficult to navigate just because it is so huge. But I hopefully this book that focuses on the contract law chapter book of the Civil Code will really help those of you who are just navigating your way through the Civil Code, particularly in relation to contract provisions. Because there's no doubt that from now on, from January 1st of January 2021, the contracts, whether it's involving foreign parties or domestic parties in China, will refer to the Civil Code, and the courts in China have been applying already the Civil Code for the past 5 months since it was effective in 1st of January 2021. It was passed in May last year. So let me just see what I can share. Okay, all right. So you should see these slides, and I'm going to talk about the new provisions of the Civil Code pertaining to contracts. But before I do so, I think it's important, perhaps given the mixed audience that we have today, just to provide some background to the Civil Code. And before that, actually have a kind of brief overview of Chinese contract law since the 1980s. I mean, I'm happy to, obviously, my book covers a historical background, but it's really from the 1980s, I think, that we see contract law becoming on its own an important piece of regulatory framework for governing China's economic transition as well. And then at the end, I will talk just about a case on force majeure and change of circumstances, because obviously COVID has impacted a lot of contracts in terms of performance, and I think just having a kind of real life case just to illustrate the importance of the Civil Code would be very helpful for our audience. So just to start with Chinese contract law, in the 80s, those of us who can still remember the 80s, it was governed by 3 pieces of legislation, and it was the economic contract law, the foreign economic contract law, and the technology contract law. And essentially, these 3 pieces of legislation in the 80s was part of the overall development of China's economy when it came to state planning. So it wasn't really about party autonomy, freedom of contract. These 3 pieces of legislation were introduced as part of this broader goal of market reform, very state-driven, top-down oriented legislative changes. Now, the regulatory scope of these 3 pillars of Chinese contract law in the 80s excluded natural persons. So a natural person, a Chinese citizen, couldn't actually enter into a contract that was governed by any of these 3 pieces of legislation. There were lots of overlaps, conflicts, inconsistencies between the 3 pieces of legislation. And some of the basic rules of contract law, such as contract formation, were not found in any of these 3 pieces of legislation. Now, alongside these 3 contract laws, there was the very important general principle of civil law that was promulgated by the National People's Congress in 1986. And that actually then introduced sort of the separation of contracts for economic planning and then contracts that actually did include natural persons. But at the same time, there were only 10 provisions related to contracts. It covered other areas of civil relations, such as tort and sort of personal, some elements of personal privacy. But we can see basically the civil code expands on these different areas of civil law in a much more comprehensive manner. So the contract law, Chinese contract law really kind of came into being, I think, in 1999, when there was the first comprehensive unified piece of legislation, the contract law of the People's Republic of China in 1999. And that was in partly sort of, I think, actually primarily to do with the transition of the Chinese economy again at that point in the country's history. We recall the accession to the membership of the World Trade Organization. So many commentators have said this was part of the legislative changes that China had to make in order to fulfill the conditions of its accession to the WTO. Now, the contract law 1999 legislation, it brought a lot of clarity. It repealed the three pieces of legislation from the 80s, and it brought a lot more clarity and more comprehensive regulation of contracts in the PRC. And when you look at this contract law 99 in more detail, you realize that actually there's a lot of influences from different international and comparative sources. So it's not, even though China is a civil law tradition, so its civil legal tradition is from mostly continental Europe, but the 99 contract law legislation actually reflected some common law influences, and more importantly, the international sources of norms. So the Convention on the International Sale of Goods, and also the UNODROIT principles on commercial contracts. So it really tried to represent kind of a blend of different comparative sources and international sources in the area of contract law. And what was really important about the 99 legislation was also the emphasis on party autonomy. There was a lot less room within the provisions of that legislation that referred to administrative or judicial interventions. So yeah, the 99 legislation was a massive leap, and it reflected obviously China's transition to a much more market-oriented economy in the late 90s. Now, fast forward about 20 years, about 20 years, yes, since 19, it's sort of time flies, I think. Those of us who remember all the debates in the National People's Congress that led to the final promulgation of the Civil Code in May 2020, would recall just sort of how difficult the process was. The Civil Code is something, for Chinese civil law scholars, a bit of a dream. Generations of scholars have worked on drafts of the code. It got knocked back quite a few times before the legislators. And what happened was basically separate pieces of legislation in the different areas of civil law were issued. And so you have, the law on succession, marriage law, succession, the general principles of civil law, adoption law, contract law, law on property, real rights, and tort law. So there were basically Chinese civil law, private law, was just basically this kind of smorgasbord of different legislation over the decades. And because of, I guess, the influence of continental civil jurisdictions on Chinese legal system, the idea of having a code was something that was just sort of a mark of an advanced civilized legal system. And this is why the civil code in China has been seen as such a major accomplishment by Chinese jurists and lawmakers. So there are 7 books that basically brings together these different pieces of legislation from over the years governing different areas of Chinese civil law. And you can see here, I've highlighted the different books. My interest is mostly on book 3, on contracts, but of course, all the other books are also relevant, I think, for practitioners and researchers of Chinese business and commercial law. I think what's really interesting is that you have a separate book, for example, on personality rights. That's definitely something that there wasn't actually a separate legislation for personality rights, but in the age of big data, personal data protection, privacy, data privacy, the legislatures felt it was important to have a separate book with the protection of individual rights in this area. There are other new provisions that, I mean, again, I won't have time to talk about them, but you know, some of these provisions are kind of more innovative and reflects, I think, lawmakers' desire to have this forward-looking piece of legislation and it's a foundational legislation for different areas of Chinese civil law. So there are many interesting provisions. I'll focus on the contract law provisions for today. So basically, as I've said, most of the contract law provisions are in book 3 of the Civil Code. But book 1 has the general provisions that apply to you know, all civil juristic acts. So it covers the other books as well, which includes contracts. So it's important when analyzing a case to refer to both book 3 and book 1 in terms of a contract law case. There are some, the fundamental principles more or less remain the same. So that the Contract Law 1999 articulated a range of fundamental principles of Chinese contract law. These principles more or less are still there in the Civil Code. Civil Code does introduce a new provision, which is a green provision, which I guess, again, reflects some of the high-level policies that Chinese lawmakers have been articulating over the last few years. So the green principle is about, you know, performing contracts in line with environmental preservation and etc. So it's quite vague, but I guess the policy intention is there. I don't know how that's actually going to be implemented in practice. And you know, there actually is specific provision on performance in Article 509 of the Chinese Civil Code that says parties should perform these contracts with you know, attention to not wasting resources, right? So yeah, again, there's a big question mark on how is, you know, we're gonna, let's have a look at whether cases pop up that where someone's going to argue, oh, the other side in performing the contract has breached Article 509 and has been in breach of this green principle. Yeah, I don't think I've found any case yet, but at the same time, it's there. So that's quite an interesting new provision, again, reflecting high-level policy kind of directives about environmental preservation, ecological civilization of the PRC, etc. So when we look at book 3, the substantive rules on contracts, there are a few changes, which I will point out some examples, but more or less the general rules are very similar to those found in the 99 legislation. Now, the two Supreme People's Court judicial interpretations related to the 99 contract law have been repealed. So the Supreme People's Court last year was very busy. I talked to some of the colleagues there. They were busy going through about 500 judicial interpretations that were related to the Civil Code and had to tidy up some, repeal some, refine some, and it was these two major provisions, judicial interpretations that basically got abolished because many of the rules can be found now in the Civil Code. So some examples of the changes to this contract law 1999 legislation that the Civil Code brought in. So part 3 of book 3. So part 3, the book 3 on contracts is split into 3 parts. The first on the general rules, the second on the specific types of contracts, and the third on what's called quasi-contracts. So the 2 quasi-contracts that actually have their own provisions under the Civil Code, book 3 on contracts, include this concept of negotium. My Latin is not very good. Negotiarum gestio, which basically refers to a situation where someone voluntarily manages your affairs for you, right? So there's no contract between the 2 parties, but basically it's similar to agency, but there is no contractual relationship. It's when someone maybe due to emergency, steps in and manages your affairs for you. So, for example, if you, you're on holidays and suddenly there is a scale 9 typhoon in Hong Kong, and your neighbor steps in to help basically, prevent flooding to your house. Now, that's a situation where your neighbor has, it's not a contract, but they've voluntarily taken obligations that are like contractual obligations to manage your affairs for you. So I think that's probably a simple example of negotium gesto. And then, of course, there's also unjust enrichment. So some in the audience may know this term, but essentially the idea that someone without any contractual basis was unjustly enriched, so gain something from the other person without actually any contractual lawful basis for that gain, and so has to return that enrichment because it was unjust. So there are new rules also based around contract formation in the Civil Code. For example, in the 99 legislation, parties, it was offer and acceptance that was the main model of formation of a contract. Now, the Civil Code actually allows for any other methods. So it's showing that actually offer and acceptance may not always be the best model of contract formation. And we know, the kind of battle of the forms, like I send you an offer, counter offer, and finally you're just like, okay, well, at which point is acceptance, which is crucial, obviously, in terms of trying to get that last shot, to say, okay, this is the last version of the contract. That can be quite a difficult process of contract formation. So now the Civil Code does recognize other methods of formation of contracts. And also introduces, for example, contract formation in e-commerce transactions, which is something that wasn't referred to in the 99 contract law legislation. Validity of contract is also an area where we see new provisions in the Civil Code. So there was a contentious provision about unauthorized disposition of another person's property that could be subject to subsequent ratification. The Civil Code now removes this provision, refines the principle, which is much more in favor of just particularly in the context of bona fide third-party purchases. And it's been put into the property book of the Civil Code. So it's removed it from the contract provisions in Book 3. There's also, the Civil Code covers the possibility of rescinding a contract, revoking a contract, where the fraud or duress is caused by a third party. It also integrates 2 grounds of voidable contracts under one umbrella. One of the grounds is taking advantage of another party's distress, and also this ground of evident unfairness at the time of the contract's conclusion. So it's now merged it into one, because a lot of jurists have said, actually, in most cases, courts in practice have actually discussed both notions together under the 99 legislation in any case. So it was a very pragmatic move to actually merge these two grounds together in the civil code. And also in the 99 contract law, it was possible for parties to request courts to modify voidable contracts. So they could either get modification or termination, but under the civil code, you can only get termination, except on the grounds of change of circumstances. So with the remaining few minutes I have, I thought it would be interesting just to look at also a change from the 99 contract law to the civil code when it comes to force majeure and change of circumstances. Now, force majeure hasn't changed really quite. There's hardly any changes to the rules governing force majeure, but for change of circumstances, the 1999 contract law legislation actually did not refer to this concept of change of circumstances, which is a different concept to force majeure, which I'll go into shortly. It was only found in the Supreme People's Court judicial interpretation, the second one, on the 99 legislation. So force majeure essentially exempts the party from performance of the contractual obligations and allows for termination if the purpose of the contract cannot be realized because of the force majeure event. Okay, so that's the thrust of force majeure. And it has to be basically an event that's insurmountable and objective, so unforeseeable, unavoidable, and insurmountable. Okay. Now, change of circumstances doesn't require an unforeseeable, unavoidable, or insurmountable event. It simply requires, at least under the 99 contract law, those circumstances that have changed, but they're not force majeure and they're not commercial risk, where the parties could not see that change at the time of entering into the contract, but it makes it obviously unfair or impossible to realize the purpose of the contract. So the emphasis of change of circumstances is on the unfairness on a particular party when the circumstances after the conclusion of the contract have substantially changed. And under the previous legislation, there was no mention of change of circumstances, but the Supreme People's Court basically said it can't be force majeure, it can't be commercial risk. Okay, it's just an obviously unfair change of circumstances that the court can modify or terminate the contract. Now, if you look at Article 533 of the Civil Code, essentially it recognizes that it's very similar, the concept still stands, but it recognizes now that force majeure can also be change of circumstances. Okay, if the focus is on the obvious unfairness to the other party, and it provides more details of a process that parties need to undertake in order to actually apply to the court and try to either terminate or modify the contract on the basis of change of circumstances. So Article 533 of the Civil Code requires the parties to negotiate. And if they fail, then they can actually, the party that's disadvantaged can actually then bring a claim before the court. And the court, in deciding whether to revoke or terminate or uphold the contract, must look at the fairness principle in quite a lot of detail. This concept is really about fairness. Force majeure, I mean, indirectly it's about fairness, but it really has to be a really major event that's unforeseeable, unavoidable, insurmountable, that prevents the parties from actually performing the contract. Now, again, this is a major development in terms of both theoretically and practically, because when we think about what happened last year with COVID-19 and the disruptions that COVID brought to many aspects of business and commercial life in China, policymakers and the courts were saying COVID-19 and the government measures to contain and prevent the pandemic were force majeure events. We could still remember famously, because there was a lot of news about these force majeure certificates that the Chinese, the promotion, it's a quasi-government agency that issued these force majeure certificates for Chinese companies to basically say, look, we've had a force majeure event that's disrupted our contractual performance. And that raised a lot of eyebrows, I think, from the foreign press, because they're like, oh, Chinese parties are now trying to, use the government's, this quasi-agency to get away from performing international contracts. Now, it was recognized, I think, across the board that the COVID pandemic and the government measures to contain the pandemic in China were force majeure events. But what has happened is that instead of going for force majeure provisions, the courts have been looking at change of circumstances provisions for COVID cases, right? And so the civil code also recognizes that actually a force majeure event can trigger change of circumstances. And it's much easier perhaps for parties to prove change of circumstances than force majeure. So here I've provided a case that is about lease contracts, which obviously with the pandemic, there was a lot of disruptions to shopping malls, shopping plazas. Here the parties signed a contract, a 10-year tenancy contract from 2011 to 2020. Basically, there's a few more events that happened, but essentially one of the parties ultimately couldn't pay because of government measures to contain the pandemic, and so it was late in at the time of the case it was still owing the original claimant about 200,000 renminbi. And so essentially the court said, okay, well, we know that it was none of the fault of the parties that the government measures to close down the shopping mall happened and caused a lot of financial damage to the shops there, to the plaza, the entity that represents the plaza. So this is not, we're going to be able to apply change of circumstances, Article 533 of the Civil Code, because of the pandemic government measures. So it's not a breach of contract, and basically under 533 of the Civil Code, the court said this contract can be terminated. So it's sort of, in a way, excused. It excused the disadvantaged parties' inability to pay the remaining rent for the year of 2020 on the basis of a force majeure event, right? They could have gone the force majeure route, but the court decided to go the change of circumstances route. So, so I think the key takeaways, and I'll just wrap up, is from my talk today. It certainly doesn't encapsulate the full range of discussions and explanations of the contract law provisions in the Civil Code. That I hope you can buy the book and read it for yourself. It's not a very giant, thick book. It's I try and make it accessible to a wide audience. But the key points to take away from today's talk is that the Civil Code is a massive deal. It's a massive deal from sort of the jurisprudential development of China's legal system. It's a massive deal for practitioners because it obviously governs many aspects of business and commercial life in China. And so contracts is just one, but a significant chunk of this overall piece of legislation. I think it's important to take note of the new provisions in contract law and other areas of law governed by the Civil Code, just because it has actually, I think in many ways, improved the 99 contract law legislation in terms of clarifying the rules, adding a few rules, and just tidying up the whole framework under the 99 legislation. And finally, I think what practitioners and researchers need to take note is that the Civil Code is quite, in many ways, a foundational piece of legislation. It's meant to be there for many decades to come. And so, of course, we know society change, we know even the nature of business and commerce change. And so it's important to kind of take note of the implementation of the code that will evolve, because you will get new normative instruments that tackle maybe new issues that were not covered by the code. Code is fairly comprehensive, but of course there's going to be new issues that arise. So it's important just to kind of keep track of a range of different normative instruments, for example, the judicial interpretations of the Supreme People's Court and other judicial documents that will certainly accompany the implementation of the code. So thank you for listening, and I think I'll turn it over to perhaps William, and we can also have some questions.
Okay, thank you, Mimi. I think this book comes just at the right time. I recently conducted an arbitration, a 10-day arbitration, and the arbitration, the relevant contract, is governed by PLC law, right? And therefore we have to dig quite deeply into the intricacies of PLC law. And increasingly, I think doing business in this part of the world, you cannot escape the operation and impact of PLC law, contract law. And in order to have a ready access to this body of law, I think Mimi's book is actually a very convenient and very comprehensive guideline. So the practitioners or students who like to understand PLC law, I think Mimi's book will be the first point of call to get a hold of this new regime in PLC law. So while I'm not receiving any commission for the selling of this book, I would certainly recommend you to get hold of a copy of this book because it's an essential lawyer's tool to understand this emerging and important area of law. Now, Mimi, I have one question for you on your book and this new PLC law, contract law regime, book 3 under the Civil Code. Is this principle of evidently fairness? Because you talk about the fairness principle quite substantively in your introduction. And it's a concept which I also find a bit difficult to grasp when I was conducting my arbitration. Whereas under our traditional common law regime, the court or the tribunal doesn't look at the relative fairness of a deal. If you enter into a bad bargain stupidly, then tough luck, right? But perhaps I'd like to know if you can share with us your understanding of how this evidently fairness or this fairness principle works in regulating the contractual rights between parties or contract.
Thank you very much, William. And thanks, indeed, you don't get a commission. I think you've been a very good friend and supporting my work over the years. So I'm very grateful indeed for your very kind words. Yeah, I really hope it will be useful for practitioners and like yourself who do a lot of arbitration in cross-border contractual disputes. And Wei Xia as well, she's also an arbitrator in this area. So I think in terms of the concept of fairness and then, the ground of evident unfairness when it comes to voidable contracts in the context of PLC contract law, it's a very difficult concept for, I think, common lawyers to understand. And that's one of the areas that I do try in my book to explain with a bit more detail. In many ways, the book is written for common law lawyers. I myself I'm qualified in Australia and the UK. And so I think this concept of unfairness is one that it's hard to kind of, have coming from a common law background to really grasp, because it's not a fundamental principle in our own legal system. but it's fundamental in the Chinese legal system. So as a fundamental principle, you have the principle of fairness. Now, does that mean, fairness in terms of rewriting the party's bargain? Now, this has been controversial because Chinese courts have taken different approaches to this. And that's been a problem in terms of the implementation of this principle. If we're talking about substantive fairness, then yes, courts should not be rewriting parties' bargains. And it's also related, I think this principle is another related principle that is problematic is the principle of good faith. Again, we can talk a lot about good faith principle in English common law, one of my pet topics as well. But that principle in Chinese contract law is absolutely imperial. It's called an imperial principle. It's so fundamental. And so these two principles often, you would read, like I've read thousands of court judgments over the years, because I also wrote a book on the 1999 contract law, and you will just see courts basically just jumping to, like, the basis for their decisions would be on the principle of fairness and the principle of good faith. And they don't actually cite, what the actual provisions of the contract law, or they may mention it, but they don't actually do the same kind of analysis that we expect, say in a common law kind of context, where you actually have to go through what was unfair, why was it unfair, and why the courts would actually then intervene effectively in the party's bargain by evoking these, kind of vague principles. So I have to say, there's not been a consistent implementation of this principle in the court cases, and that's very frustrating, of course, because it obviously leads to criticism about, okay, partiality of the courts. If I'm going against a local state-owned enterprise, in a third-tier city, am I going to be subject to this kind of arbitrary application of these principles that are very vague? And sometimes people say they're deliberately vague to create this discretion for courts. But I think things have tightened up, and the Supreme People's Court having, over the years, you see it with, for example, guiding cases, which they're not precedents, but they've been developed by the Supreme People's Court to try and kind of tighten the rein on, local courts' loose application of these principles, like evident unfairness, good faith. And so I think that there are definitely more attempts to be more consistent. But yes, I agree with you that this principle is still one that, because of how loose it is, I think these days local courts are expected, though, to actually identify other provisions to base their judgments on, and not just, oh, this contract was evidently unfair.
The other principle, which I find quite interesting, is this new green principle that you just outlined. Right. So about the importance of environmental protection, I suppose. But how does it work when the parties sign a contract? For example, let's say a contract to buy crude oil or develop a factory, for example, in China, between the parties. So how does this general principle in relation to environmental protection affect the parties' private rights contractually if they've agreed into it? So how does it work? Does the state regulate or invalidate certain provisions of privately drafted contract? How does it work?
Yeah, it's a great question, William. So as I've said in my talk, I think this is one of the principles that, is for show. I think in many ways, I find it difficult to imagine how parties would be, okay, well, we better make sure, review this contract that we've just entered into and make sure we, abide by this principle. I think in practice that probably doesn't happen. But again, it's this kind of symbolic importance of the civil code from the Chinese lawmakers' perspective, that it needs to reflect some of these grand policy themes. And we know that, under President Xi Jinping, this ecological civilization idea and environmental protection have received a lot of attention. So I think this is actually sort of an example of a policy, high-level policy kind of posturing, like, you know, that the code has to reflect modern issues like the environment. Whereas in terms of actual implementation, as I've said, there's only one provision in the book 3 of the Civil Code on Contracts, which is about performance of contracts, that you shouldn't be wasting resources, right? But who's actually going to be, you know, if I really wanted to bring a claim against you for, defective performance of the contract, I'm just trying to think of a scenario. Maybe I can say, look, you've been wasting all these resources and therefore you're in breach of this article in the Civil Code. I'm just trying to think of a situation where, as a lawyer, I might be able to cite that provision and the principle of environmental preservation. But I wouldn't just rely on it. I think you have to bring a series of different other claims. But I could try, it really depends on the situation. If you were wasting resources and I was expecting you to perform the contract in a much more efficient and affordable way, I might try and use this argument. But again, I haven't found any cases at this moment that refers to this principle. So we wait and see.
Right. Now, my last question before I pass the the airtime to the floor is on contract formation. You just mentioned over acceptance and by means of other methods. So what does it mean by other methods? What are the other methods encapsulates?
Yeah, it's a very, very good question. Again, this is something that I think when this book will be updated in about a year and a half's time. So I think by then we'll have more cases on illustrating what these other methods are. So I can't speculate at this stage because I still think the courts at the moment are still applying the offer and acceptance model, right? Because they are the ones that's the model that they're most familiar with, right? Because that's from the 99 contract law. So I guess, other methods will be looking at where, again, I'm just trying to imagine like kind of, possibility where it wasn't very clear that there was an offer and an acceptance. Yeah. So those kind of cases where, maybe the party's intention was to come to an agreement, that there was meeting of the minds, but it's not so clear that there was actually an offer and acceptance. So I think in some of the European civil law jurisdictions, I think that there is this kind of, okay, well, we're not looking for signs of an offer and signs of an acceptance, but if we can see from all the evidence that there was actually an intention to enter into a contract, then that's good enough. So I think Lord Denning, in some of his cases have rejected the offer and acceptance model in English contract law. So I think that's a sort of, I think that the other models envisage that sort of other ways beyond, a clear offer and acceptance mode of formation.
Thank you, Mimi.
Thank you, William.
I'm not quite sure I'm supposed to read out these questions. Is my job or is it the host or whose job? But let me do this. There is a question from Dr. Hong from Hong Kong U. There's many thanks for Dr. Chow's presentation. Your book is very comprehensive and must read for lawyers interested in Chinese law. I want to raise one question about your presentation. Usually public law is an area where political powers can easily have over. But private law is an area where political powers cannot easily have impact on. Based on your research, do you find any political influence over the development of the civil code in China?
Yes, the answer is yes, because I think basically I think there's political there's political influence over any areas of lawmaking in China, right? So the process itself, but also substantively, as I've used the example of the green principle, you could see that it was very much a nod to the kind of political a policy paradigm of, ecological civilization, environmental preservation. But I think, I think the process itself is interesting because, and I write, this is in chapter 1 of my book, I look at actually the link between why did the Civil Code came in 2020, and why it was obviously made a very big deal. I mean, they kind of reconvened. Well, there were other reasons why they reconvened the Shuanghui NPC and the party decision-making bodies. I mean, essentially, this was a moment where President Xi Jinping wanted to say, look, under this administration, we have enacted the Civil Code, which took decades. I mean, obviously, that wasn't planned, that it was, it failed several rounds, and it now is under President Xi Jinping's administration that it finally got enacted. But I think the timing really suited him very well, because it was very much weaved into this whole, fourth plenum, governing the country by the rule of law, promoting individual rights, very interesting kind of concept here that certainly interacts with, the very fine boundary between public law and private law in China. And so I think, the political influence over what is really a private law, like a body of private law, is certainly there. There is certainly a lot of political undertones in some of the new provisions, it's just, I think that's a sort of a characteristic we see in Chinese law. So that's a great question. Thank you.
Mimi, we still have about 5 to 10 minutes. There's another question raised by our very eminent professor, our chair professor, who just very recently joined us, Professor Alex Stone-Sweet, our new chair professor on comparative public and international law. Thank you very much, Alec, for attending the talk. So his question is about, and then the inspiration of the question is from the exchange between you and William, the scope of discretion given to Chinese judges under the new code to impose principles, to interpret the code in creative ways. So he lists more examples in addition to about, freedom, as you said, about, what is good faith, what is equitable sort of fairness, what about good morals, public order, good faith, personality rights. And then he raised it in a more comparative contextual setting. These clauses have radically expanded the power of courts. It might be that you have partly answered the question already, but this new code appears to Professor Stone-Sweet to have quasi-constitutional features, because, as I explained to you about Professor Alex Stone-Sweet's background, that appear all the more important given the non-justiciability of most constitutional provisions. I have a lot of questions myself, but I will hand over back to you first for
That is a fantastic question. And I'm just thinking I could write a paper. Maybe we can work together on this, Alec. It's a really fantastic question that I mean, I'm a private lawyer. So in a way, I'm just so excited just thinking about actually the quasi-constitutional nature that you've mentioned of the Civil Code, because it is a foundational instrument for a range of individual rights, which, if you look at the Constitution of the PRC, and we're still on the 1982 version, some of these rights are kind of there, but expanded, I think, in the Civil Code. So, for example, the right of private correspondence between citizens. They don't say privacy in the 1982 Constitution, but, now we have a whole chapter on personality rights that cover a whole range of privacy rights and private, in the context of private correspondence, particularly in the context of the internet. And it really does look, actually, I wouldn't go as far as like a Bill of Rights for individuals, but I think, certainly we're looking at least in the Civil Code, rights that can actually be exercised against public authorities and government agents. So these are obviously kind of rights that cover individuals to individuals. So, Tencent can't infringe on my data privacy rights. There's a new legislation that's going to come out, but you know, certainly these can be enforced if it's in a kind of civil relationship with a government body, so you know, whether it's a state-owned enterprise or a government body. So it's you know, it's kind of going into administrative constitutional law, but you know, at the same time, I think I could see though still in some cases the courts may say, oh, that's actually an administrative matter, a public law matter, it's not relevant for civil law. But I can see that civil code, given the kind of the quasi-constitutional nature that you talk about, could actually make some leeway into actually expanding protection of individual rights, civil rights that are contained obviously in the PRC constitution, but are actually in the context of private law. So I'm very excited actually about this thought, this argument that you have. I don't know, it really depends on the courts about how they will potentially interpret these kind of different principles, which I agree with you are quite, you know, they're quite vague and general still in the civil code. And it could be that the Supreme People's Court want to kind of restrain local courts' discretion and perhaps issue new either judicial interpretations or other forms of judicial normative documents to say, okay, what is then, you know, good morals and public order, or like, you know, how should you interpret good faith in the context of contractual disputes, personality rights. I do see that there is going to be, you know, certainly some movements by the Supreme People's Court in trying to control how local courts will apply this. But certainly it's exciting to think about actually the civil code, even though it regulates private law and civil law between citizens, it actually can become a bridge to protecting perhaps more broadly you know, constitutional rights of Chinese citizens. So we'll be really interested in connecting with you after this talk to discuss whether we can, work on an article together. Great.
Right. I myself have a lot of questions. Say like, you know, contracts, when you say, Mimi, you have part 1, part 2, and part 3. I understand the point from Dr. Hong, I mean, Feidi, and then Professor Alex Stone's, you know, contract law is in between of private law and commercial law. I think William might share same experience as me, because we both sit as arbitrators in international arbitration, especially on Hong Kong, mainland China cross-border context. So when we are in the arbitration setting, in most of the cases, not all, in most of the cases when we are facing arbitration cases are international trade law. So international sales of goods. I don't know whether you share the same experience, William. So when we are facing international sales of goods, it's more commercial than civil. And then the influence that we are receiving in applying the contractual principles would be more internationalized.
Yeah.
Certainly we look at contract law, but you will see that the arbitral tribunal goes beyond that, and then the influence is from CISG more than that from contract law itself. So I would be more interested, or perhaps, you know, more curious to learn about the interface between the CISG and the contract law in the real working in the Chinese courtroom. Of course, I'm familiar with how that works in some of the arbitral tribunals, but how that works in the Chinese courtroom. That's the first question. And then, I mean, if we run out of time, and then we can always exchange by email. The second one, I recall that in the 1999 contract law, well, the contract will be void, not voidable, void, if the contract provisions, they are against the national laws, national principles, or if they are criminal, illegality principle. And then there is very interesting debate about what level of the national laws that you're referring to. So, you know, under the legislation law, we have constitution, laws, administrative regulations, departmental rules, whatever. So which law? So is there any update or change in the 2020 codes? And
Yeah.
third question, and then perhaps, if there is time, force majeure and change of circumstances, they are intertwined. So is it really the case that, it's really for the lawyer to argue in the best interest of the clients that which argument will go forward? Because, many a time they both work, and then they are very much intertwined. Yeah.
Great questions, Weisha. So the first question, I think, just a simple answer. Sorry, it's a long. I'm trying because of time. I just try and condense my answer. I mean, the CISG. I mean, remember, China has ratified the CISG like 35 years ago, I think. So it is actually meant to be reflected in, and it was reflected in the 99 contract law, and obviously the civil code, because most of the rules under the 99 legislation have been included in the civil code. So, in principle, there shouldn't be, as a practitioner, too many conflicts between the CISG and Chinese contract law. The Chinese contract law may not articulate perhaps provisions related to some of the international cross-border dimensions, and then in which case, if it's a procedural question, you should have a look at the civil procedure law, which I'm sure you're familiar with because you're a dispute resolution specialist. But in terms of the substantive rules, because China undertook this commitment to implement the CISG into its own domestic law, I don't think it raises really significant conflicts with the CISG. So the courts, in China, I think if it's a contract law, a contract that's governed by Chinese law, so the civil code, they will apply the civil code. I guess they could, in some circumstances, and you can probably provide examples where there may be some clarification related to CISG. Again, you as a practitioner, you would have more experience. I guess that's when they may have to look into CISG kind of interpretations. But I think their primary basis would be looking at just the Chinese contract law and the civil code. That, in principle, should reflect the CISG. And the second question, which is a really good one, about it shouldn't violate national laws. Now, it hasn't really changed that much since 99 legislation. So basically, the provision is about that you can't violate. So a contract will be void if it violates the mandatory provisions of laws and administrative regulations. So laws being the laws promulgated by the National People's Congress, and administrative regulations being the administrative regulations promulgated by the State Council. So you can't go below that. If you violate a departmental rule of the State Council of, like, say, ministry, or if you go violate a local government rules, you cannot argue that a contract is void, right? It has to be mandatory provisions. What does that mean? Well, that's like a whole other lecture. So I guess the mandatory provisions will be those provisions in laws and administrative regulations that, if there was a breach, then it will render the contract invalid, void. I know it's a circular argument, but that's actually what the Supreme People's Court have said. So it will just depend on the case in hand. And then finally, remind me what was the last question? It was about
well, the last question is about, how do you see, what is it? Let me see.
I'm sorry, I should have written it down.
I put forward, when I put forward, and then I pass it over to you. Well, I mean, never mind. We have a lot of chances to
yes, absolutely. Let's continue this conversation.
Yeah, I
see.
I see the time is up, and then it's very nice conversation. And then thank you so much, Mimi. And then many thanks to William, and then to our very enthusiastic audience, in particular to Professor Alex Stone-Sweet, and then Dr. Fadi Hong, who raised very good questions, which stimulate the discussion. I think this is just the start. So I hope we will invite Mimi and William back to Hong Kong U with a live stream or, in physical form.
That would be great.
Yeah. So thank
Great.
you very much, everyone. And then see you next time. Bye.
Thank you very much. Bye.